Going back to contracts, part 2, we will talk about the different kinds of contract, but this time according to its name or designation. Ano ba yung kinds of contract according to name or designation? It may be nominate contract or innominate contract. Pag sinabi nyong nominate contract, which has a specific name or designation in law. Okay? Ito yung mga kontrata na merong pangalan at specific designation sa batas, gaya ng contract of lease, contract of agency, contract of sale. Ito yung mga kontratang may pangalan. Yung iba naman, when you speak of innominate, that which has no specific name or designation in law. Walang pangalan. Okay? So, unahin muna natin yung kinds of innominate contract. Do ut des, do ut facias, facto ut des, facto ut facias. When we speak of do ut des, ibig sabihin nun, I give that you may give. I give that you may give. Meron akong ibibigay kung meron kang ibibigay. Do et facias, I give that you may do. May bibigay ako kung may ginawa ka. Facto ut des, I do that you may give. Gagawin ko kung may ibibigay ka. At facto ut facias, gagawin ko kung may gagawin ka. Okay? So, actually, yung do ut des, pag sinabi mong do ut des, I give that you may give, however, is no longer innominate. Kasi, tawag na natin doon pwede ay barter or exchange. Okay? Pag sinabi yung reasons for innominate contracts, the impossibility of anticipating all forms of agreement on one hand and the progress of man's sociological and economic relationships on the other hand justify this provision. A contract will not therefore be considered invalid for failure to conform strictly to the standard contracts outlined in the Civil Code. It is sufficient that it has all the elements of a valid contract. Regardless yan, kung may pangalan o wala, ang sinasabi ng batas, basta nandun lahat ng elements of a valid contract, whether ito ay nominate at innominate, it is a contract. So, what are the rules governing innominate contracts? Ito yung first, the agreement of the parties. These are the rules. Number 2, the provisions of the Civil Code on obligations and contract. 3, the rules governing the most analogous contracts. And 4, the customs of the place. So, importante pa rin, agreement of the parties. Number 2, kung merong provision ang ating Civil Code on obligations and contracts, ito na nga yun. Number 3, rules governing the most analogous, yung pinakamalapit na kaparehong contract. And the customs of the place. Contracts binds both contracting parties, of course. Okay? Ito yung mga tinatawag natin na a contract is an agreement which gives rise to obligation. It must bind both parties in order that it can be enforced against either. Without this equality between the parties, it can be said that the contract has the force of law. Kailangan, class, paano nyo titignan na yung kontrata, dapat ba yung dalawang parties should be involved? Dapat, kasi kayong dalawa ang parties to a contract. So, hindi ba pwedeng isa lang ang nagbe-benefit sa isang contract at isa lang ang uma-agree dun sa kontrata mismo. Okay? Because persons affected by a contract, the general rule is that a party's rights and obligations derived from a contract are transmissible to successors. However, under Article 1311, Paragraph 1 of the new Civil Code, contracts take effect only between the parties, their assigns, and heirs. This means that only the parties and their assigns and their heirs can have the rights and obligations under the contract. Okay? Kasi ito lang yung mga persons na affected ng contract. Tandaan nyo ha, yung persons doon sa kontrata mismo, nandyan yung successor, or yung assignees, or of course yung heirs nila. So, kino-consider at alam ng batas na bukod dun sa parties na yon, posibleng merong heirs and assignees. Ito na yung exception. Okay? The exception is, of course, when a contract are effective only between the parties, or when the rights and obligation arise are not transmissible by their nature, by stipulation, or by provision of law. Ano yung ibig sabihin? Pag sinabi mong by nature, like a contract involving personal qualifications, as painting, kung ang kontrata nyo ay magpipinta, namatay, pwede ba ipasa? Hindi, kasi ito ay personal qualification. Number 2, stipulation. Kung yung in accordance with the principle of freedom to contract, very, very clear naman. Hindi, sasabihin doon, hindi pwedeng maipasa sa iba. So, dapat, in contract, will only involve the party itself. Okay? The parties or the party na naatasan gumawa. Pag sinabing hindi pa pwede, so hindi pa pwede. And by provision of law, as in agency, partnership, when that extinguishes the legal relationship. Dahil sa partnership, hindi pwedeng ipasa sa heirs. Pag namatay, patay. Okay? Patay na. Hindi na matutuloy ang partnership. Kaya yan ang isa sa mga reasons why I don't like partnership when it comes to business organizations. Okay? Ano yung mga tinatawag nating cases when strangers or third persons affected by a contract? Okay? Ito yung a third person is one who has not taken part in the contract and is therefore a stranger to the contract. As a general rule, a third person has no rights and obligations under a contract to which he is a stranger. He has no standing in law to demand the enforcement of a contract or question its validity. Hindi pa pwede. That is the rule. Hindi pa pwede, lalo na kung wala namang involvement yung isang party na yon. Okay? However, there are cases when third persons may be affected by a contract. Ano yon? Ito yung contracts containing a stipulation in favor of a third person. Pag meron tayong contract at nakalagay dun sa stipulation itong kontrata na ito ay para sa kabilang para sa isang third person. Ang tawag dun class ay stipulation for at truly. Okay? Classic example niyan is insurance. I will discuss it later. In contracts, number 2, in contracts creating real rights. Number 3, in contracts entered into to defraud creditors. And number 4, in contracts which have been violated at the inducement of a third person. Babalik ako sa number 3, in contracts entered into to defraud creditors. Yung papasok yung dalawang tao, magbabayad kunyari yung si debtor kay A, yun pala, kaya siya nagbabayad para lokohin naman si creditor na isa. Okay? That is the definition of in contracts entered into to defraud creditors. Now, meaning of stipulation par atruui. When we speak of stipulation par atruui, it is a stipulation in a contract clearly and deliberately conferring a favor upon a third person who has a right to demand its fulfillment provided he communicates his acceptance to the obligor before its revocation by the obligee or the original parties. Okay? Technically class, ang sinasabi lang ng stipulation for atruui is merong stipulation, okay, na magbe-benefit sa isang third person. So, pag nangyari yun, meron siyang right to demand sa fulfillment. Dapat lang, ang importante rito is he communicated his acceptance doon sa dapat sa obliger na to. bago ma-revoke. Halimbawa, insurance, di ba? Nag-enter into insurance A and insurer. Si A, si A ay nagkumuha ng insurance kay insurer. Pag namatay siya, mapupunta kay B. This is a very classic example of stipulation for a truey. So now, kung assuming nalaman ni B, kunyari, na siya yung magbe-benefit doon sa insurance, dapat yung acceptance niya, napaalam niya na kay insurer. Bago i-revoke, kung i-revoke man ni A yung kanyang insurance policy in favor of B. Okay? So what are the classes of stipulations for a truey? Stipulations in favor of a third person may be divided into two classes. Namely, those where the stipulation is intended for the sole benefit of such person. This stipulation is in effect confers a gift, it being necessary in such case to apply the rules relating to donations insofar as the form of acceptance is concerned. And number two, those where an obligation is due from the promisee to the third person, which the former seeks to discharge by means of such stipulation. As for instance, where a transfer of property is coupled with purchaser's promise to pay a debt owing the seller to a third person. Okay? Ito yung mga example ng stipulation for a truey. In the first case, the third party is said to be a donee beneficiary, while the second, he is called creditor beneficiary. Okay? Ganun lang kasimple ang class. Number one, yung stipulation is intended for a sole benefit. So, ang tawag doon, donee beneficiary. Wala naman siyang ibang hinihiling. Basta ibibigay niya lang yung whatever. Okay? Usually pera. Lalo na sa insurance. Pero itong creditor beneficiary, ang sinasabi naman dito, those where an obligation is due from the promisee to the third person, which the former seeks to discharge by means of such stipulation. Okay? For example nga, transfer property coupled by purchaser's promise to pay a debt owing from the seller to a third person. What are the requisites of a stipulation for a truey? Number one, the contracting parties by their stipulation must have clearly and deliberately conferred in favor of a third person. Dapat clear ang usapan ng mga contracting parties through stipulation. Okay? Na ipinapasa o binibigay sa isang third party ang favor. Number two, the third person must have communicated his acceptance to the obligor before its revocation by the obligee or the original parties. So, ibig sabihin, dapat i-communicate niya na ang kanyang acceptance. Number three, the stipulation in favor of the third person should be a part, not the whole of the contract. Okay? So, ibig sabihin, part lang, hindi pa pwedeng buo. Otherwise, the stipulation for a truey is not valid. Neither of the contracting parties bears the legal representation or authorization of the third party. For otherwise, the rules on agency will apply. Okay? Anong lang ibig sabihin nun? Hindi pa pwede na yung contracting parties ay legal representation ng third party. Kasi pag ganun na nangyari, ang tawag dito, hindi stipulation for a truey. Ang tawag dito, class, ay agency. Okay? Next question. Are third persons bound by the contracts? This is an article wherein it is an exception to the general rule that a contract binds only the parties. Third person who come into possession of the object of a contract over which there is a real right are bound thereby even if they were not parties in the contract. Ito yung exception. Because a real right is binding against the whole world and attaches to the property over which it is exercised wherever it goes. Okay? So, ito yung exception. Pag, class, pag yung third party comes into a possession of the object of a contract over which there is a real right. Pag sinabi nyo real right class, ito yung usual dito is the real property. Okay? Meron siyang claim over the property. Pero, pag hindi ito nga class, masyadong malalim na ito, pero we will just say it like that because usually nangyayari ito sa mga property sale of real properties. Okay? What else? Now, next, ang next discussion is according to perfection. Pag sinabi natin according to perfection, there are 3 kinds of contracts. Consensual, or that is perfected by a mere consent, consensual. Real contract, that which is perfected by the delivery of the thing, subject of the contract. Number 3, solemn contract, or that which requires compliance with certain formalities prescribed by law. Such prescribed form being thereby an essential element thereof. Importante yun. Tandaan natin ha, consensual, consent lang. Real, kailangan may delivery. Number 3, solemn, merong formalities required by law, especially yung pagbenta ng lupa. Okay, pagbenta ng lupa, solemn yan. Kasi kailangan merong documentation, hindi pa pwedeng wala. Okay? So consent, hindi pa pwedeng bumili ka lang, okay na. So ganun ka importante yung perfection ng contract. So what are the stages in the life of a contract? Una, preparation or negotiation. Pangalawa, perfection or birth. Pangatlo, consummation or termination. Pag sinabi mong preparation or negotiation, this includes all the steps taken by the parties leading to the perfection of the contract. Ito yung stage na to, wala pang napagkakasunduan na definite ang bawat parties. So ito pa lang yung panimula, nagsisimula pa lang. So when we speak of perfection or birth, this is when the parties have come to a definite agreement, or eto na yung meeting of minds regarding the subject matter and cause of the contract. Okay. And number 3, consummation. This is when the parties have performed their respective obligations and the contract may be said to have been fully accomplished or executed, resulting in the extinguishment or termination thereof. Okay? How are contracts perfected? Consensual contracts, as a general rule, are perfected by mere consent. Tandaan nyo, consent lang, pwede na. Example, today, S and B entered into a contract whereby S bind himself to sell his car to B for 200 pesos. The contract is deemed perfected, although there is no delivery of a car or payment of the price. Both parties acquire the right to demand from the other the fulfillment of his obligation. Okay? Ano naman yung real contracts? The exceptions are the so-called real contracts, which are perfected not merely by consent, but by delivery, actual or constructive. Dito may delivery kailangan. Ito yung mga kontrata na kailangan merong delivery of the object, actual or constructive. Pag sinabi mo actual, tinanggap mo mismo dalawang kamay. When we speak of constructive, pwede mong iabot. Halimbawa, yung kotse, pag inabot mo yung susi, well, that is already considered constructive delivery. Okay? So, these contracts have for their purpose restitution because they contemplate the return by a party of what has been received from the other. Example, D borrowed from C 5,000 pesos as a security for the debt. D promised to pledge his diamond ring to C. Before the delivery of the ring to C, the contract of pledge is not yet perfected. So it is important that for in that case, later on refuses to pledge the ring, C can demand the payment of the obligation, although it is with a period. But C cannot require D to deliver the ring as a security because there is no real contract of pledge yet. There is merely a consensual contract. Okay? So, naintindihan nyo, class, ha? So, dapat, pag naibigay na yung pera, tsaka mo lang i-require. Pero kung hindi mo naman binigay yung pera, hindi ka pa pwede mag-demand nung delivery ng ring because yung pledge hindi pa nagte-take effect. Okay? Yung contract of pledge. Kaya dito, there only exists the simple consensual contract lang siya. Okay? Consent pa lang. And when we speak of solemn, the law requires that a contract be in some form to be valid. Kailangan may special form or may papel. Depende yan kung ano yung kailangan na necessary for its perfection. Thus, a donation of real property cannot be perfected until it is embodied in a public instrument. Okay, kung ikaw ay magre-regalo ng real property, ng lupa, dapat ito ay nasa public instrument. Dapat ito ay nakasulat. The effect of a perfection of a contract. Number 1, to the fulfillment of what has been expressly stipulated, but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. That is the effect. Unauthorized contracts are unenforceable. As a general rule, class, a person is not bound by the contract of another of which he has no knowledge or to which he has not given his consent. A contract involves the free will of the parties, and only he who enters into the contract can be bound thereby. Okay? Unauthorized contracts can be cured only by ratification. Pag yung mga unauthorized contracts na pinag-uusapan natin, pwede naman siyang ma-validate, class. Only by ratification. And pwede ang mere lapse of time. Yun ba ang tanong? Pwede ba? The answer is no. Okay? Kasi nga unauthorized, so hindi pa pwede. So the defect is such that it cannot be cured except by subsequent ratification of the person whose name the contract was entered into or is duly authorized. Hindi porket lumagpas ang time, may usapan kayo, hindi naman kumikilos yung isa, na-authorize yung contract. Pwede bang ma-ratify yun dahil sa tagal-tagal? Hindi. Dapat mismo yung person na involved sa contract na hindi nagbigay ng authority, dapat magbigay siya ng authority. Hindi porket nag-lapse yung time, pwede na. Okay? Next. When is a person bound by another contract? In order that a person may be bound by the contract of another, there are two requisites. The person entering into the contract must be duly authorized, expressly or impliedly, by the person in whose name he contracts, or he must have, by law, a right to represent him. Yan yung mga tinatawag nating guardian or administrator. Guardian, pag ikaw ay naging guardian ng mga isip bata or bata, pwede. Okay? You are bound by the contract because you are the guardian. Kahit yung administrator, usually administrator ng properties, nag-a-assign yan. Kahit na hindi ka involved, pero dahil ikaw ang administrator, you are bound by the contract. And number 2, importante that you must act within your power or within the power as a guardian and administrator. A contract entered into by an agent in excess of his authority, class, pag lumagpas ang isang agent sa kanyang authority, it is unenforceable against the principal. But the agent is personally liable to the party with whom he contracted, where such party was not given sufficient notice of the limits of the powers granted by the principal. Magandang example dito again, class, is kunyari nagbebenta ng kotse si A at meron siyang ahente na si B. Si B binenta yung kotse kay C. Ang sabi ni A, ang bayad ng ang tawad lang is hanggang 50,000. So kung 300 hanggang 250. Ginawa ng B, binenta niya ng 200,000, nalugi. So, ang mananagot nun, si agent, class. Okay? Kasi hindi naman alam ni buyer na ang usapan is hanggang 250 lang. So, magabayad si agent kay A kasi ito lang ang authorized mong bayaran or authorized mong ibenta yung property. Okay? So, that is part 2. So, watch out for part 3, class. Magsisimula na tayo ng essential requisites of a contract. Okay? Or essential requisites of contract.